Hello friends, I am Murthy Dheeraj and today we are going to deal with the concept of polity that came under uh, part 3 of fundamental rights, that is constitutional remedies. So constitutional remedies is discussed under article 32 of the Constitution of India. Now why constitutional remedy is different or important from other parts? So it provides the right of the person against unnecessary or illegal detention and also safeguard some other measures of the citizen of India. So the right to constitutional remedies are provided under Article 32 in Supreme Court and under Article 226 in High Court. In general, the Supreme Court have higher capacity in jurisdiction, while High Court is having lower jurisdiction. But in case of constitutional remedies, the High Court is provided more power than Supreme Court. It means they can they can hear the issue in more cases than Supreme Court under constitutional remedies. Constitutional remedy was called the heart and soul of the Constitution by the drafting committee chairman, that is Dr. B.R. Ambedkar. So we can understand how important it is. So under constitutional remedies there are 5 writs are provided. The one is habeas corpus, and the second one is mandamus, the third one is prohibition, fourth one is certiorari, and the fifth one and last is quo warranto. So under the habeas corpus, the court asks to have the body of. It means if any person is detained, so present that person on front of the court, so that the magistrate or the court can hear the issue and they can know the real picture. Since it provides safeguards against illegal detention, so that's why it is called the bulwark of individual liberty against arbitrary detention. Means if the detention is lawful, then court have no right to issue the habeas corpus, but if it is unlawful, so they can ask for habeas corpus. So there are also some exception, and in which the court cannot issue the habeas corpus, that is if detention is lawful and if the proceedings is for competent legislature or court's contempt, then the detention habeas corpus is not can be applied. And the third case is the detention is by competent court. If the detention is done by any competent authority or court, then the habeas corpus is not provided, not available. The fourth one is if detention is outside the jurisdiction of the court. The next one is mandamus. Our next writ is mandamus. Mandamus literally means to we command. Means court says we command to perform the duty of the statutory authority. If any competent authority is able to do their work in a proper manner, then the mandamus writ can be issued against them. So the question arises whether they can be issued in any case. So answer is no. They are having limitations, and they are cannot be issued against following. So the first case is a private individual or a private body, means the mandamus writ can be issued only against the government body or the constitutional body or the statutory body or any private body which are working on behalf of the government of India or any state government. So this is a important point which is important in solving the questions. The examiner can tweak this statement. The second case is to enforce the departmental instruction does not possess statutory force. If any institution is built but is not statutory, so under the departmental instruction they cannot be enforced. The third case is if the duty in question is discretionary and not mandatory, means if any authority has done their work and it according to their discretion power, so court have not authority to issue the mandamus. And the fourth one is the president and the governor of the state, means mandamus cannot be issued against the president and governor of the states. It is also not be issued against the chief justice or acting judicial capacity. And the last is it cannot enforce against the private contract. It means if there is a contract between two persons, so if any breach of the contract is going on, so here the mandamus is not available because it is a private issue, it is not a statutory issue, and they can be safeguarded with other laws and other provision of the constitution or any statutory laws, but it will not be issued or go through the writ of mandamus. Now our important point is mandamus is also called a awakening call. Why? Because they are made in the thought that they can be like a awakening call to the authority which are not properly functioning their work or going with the lackadaisical approach. So all this was regarding mandamus. Now our third writ is prohibition. So under this prohibition writ, it literally means to forbid. Here the Supreme Court, the High Court or the higher courts can issue against the lower courts. It is categorically noted that it is not available against the administrative authority, but here the higher court can issue this writ of prohibition against the tribunal, quasi-judicial body, sub-judicial body to stop the proceedings which are going in the court, and actually it is not in their territory. If the case is not under their jurisdiction, but even though they are doing proceedings, so higher court or competent court can stop to do the same. And the one thing is noted, that is it is not available against the administrative authorities, legislative bodies and the private individual or bodies. The important point here which can uh, be helpful in solving question. That is to remember, while mandamus directs activity and prohibition directs inactivity. It means in mandamus the court asks the authority to do the work, do their job, for what they are made, for what they are sit on post. While in prohibition, they prohibit to the court not to perform that particular duty which is not under their jurisdiction or not their under territorial jurisdiction. This is our third writ, and our fourth writ is certiorari. Certiorari means to certify. Here the higher court or competent court like Supreme Court and High Court can quash the order which are already given by the lower court. It means suppose any district court or quasi judicial authority have done any proceedings and conclude their order, so the whole order can be quashed by the higher courts, that is of Supreme Court or High Court. So unlike prohibition, which is only preventive, certiorari is a kind of curative writ. This is important point. So one thing is important which can be noted, that before 1991 the writ of certiorari can be issued against the judicial or quasi judicial bodies or statutory judicial bodies, but after 1991 it was also available against administrative authorities. However, in 1991 the Supreme Court ruled that certiorari can be issued even against administrative authorities if they affect the life of individual. And the one thing is more to be noted, that it is not available against legislative bodies and private individual or bodies. So this is our fourth writ, that is certiorari. Now the fifth writ is, and the last writ is the quo warranto. So under quo warranto the court asks by what warrant. It means they ask by what authority you are sitting on the position, by what warrant you are claiming the office. This is important writ of the Article 32. It restrains the person or authority to act in office which she is not entitled to do. Here they are saying the authority to explain their authority or to leave the post. So it's a important writ available in Article 32. Another point is the writ can be issued only in case of substantive public office of a permanent character by the statute of constitution. It means it cannot be available against the private individual. The institution which are established by the Constitution of India or the Government of India by any statute. So the important point which can be remembered is, while other four writs, unlike the other four writs, this can be sought by any interested person and not necessarily by the aggrieved person. here any person can go for the writ of quo warranto, and so all these 5 writs are provided to safeguard the citizen in various unlawful detention or any kind of illegality is done against the citizen of India. So these are the 4 constitutional remedies which are available in India to the citizen. So this is our whole talk. Now we will meet in any next video. So till then, thank you.